Good morning. Thank you for joining us on this short talk in relation to regulated activities and promotions rules. Even if you're not currently FCA regulated, this may be of interest to you because it goes through the perimeter in certain cases and talks about where you may be impinging upon and need to consider whether or not you need to be regulated. Who are we? We're Myerson Solicitors. We're based in Altrincham, Manchester, and we're a full-service business law firm. We have over 160 staff, 25 plus partners. So we are a substantial firm of solicitors, and we have a good bandwidth in this area. Meet the team. This is just a section of the financial services sector group within our firm, which operates across all of our practice areas. Speaking to you today are myself, and I head up our financial services offering. We have my colleagues, Olivia Sturgis, Luke Wilkins, and Kiera Goodwin, and we'll all be talking about different aspects of the perimeter and different things that we're seeing and encountering on a day-to-day basis. So what are we going to cover? Some key regulated activities. We're also going to cover some perimeter issues. This is the FCA's regulatory perimeter, which are commonly encountered by our clients. I'd like to hand over at this point to my colleague Kiera Goodwin, who's going to talk a bit about the general background and in particular the general prohibition.
Thanks, Chris. Hi everyone, my name is Kiera Goodwin. I am a solicitor in the corporate team here at Myerson, and today I will be discussing the general prohibition, the perimeter, and arranging deals and investments as a specified activity, as well as common exclusions that may apply. So Section 19 of the Financial Services and Markets Act 2000, more commonly referred to as FSMA, sets out the general prohibition on any person to carry out regulated activity in the UK unless they are authorised, i.e. they are authorised by the FCA to provide regulated activities or are exempt. So we'll start by looking at what is a regulated activity. Section 22 of FSMA states that an activity is a regulated activity if it is an activity of a specified kind which is carried on by way of business and relates to an investment of a specified kind. The business test is not defined in FSMA, but several factors relevant to the business test are set out in the FCA Perimeter Guidance Manual, PERG, at 2.2.3G and include the degree and continuity of the activity, whether there is a commercial element, the scale of the activity, the proportion that the activity bears to other unregulated activities carried on, and the nature of the activity. Although generally it is pretty clear if someone is carrying on a business, i.e. if they are repeatedly selling services to customers in return for payment, it's fairly obvious that they will be carrying on a business in those circumstances. In terms of what amounts to an activity of a specified kind or an investment of a specified kind, specified activities are set out in Part 2 of the Financial Services and Markets Act 2000, Regulated Activities Order 2001, more commonly referred to as the RAO, and these include accepting deposits, insurance-related activities, investment activities such as arranging deals and investments, advising on investments and managing investments, mortgage-related activities, and consumer credit activities. Specified investments are set out in Part 3 of the RAO and include deposits, contracts of insurance, shares, and options, to name a few. Breaching the general prohibition is a criminal offence. Therefore, to determine whether a relevant business falls within the scope of the FCA regulations, in the first instance, it will be necessary to conduct what we refer to as a perimeter analysis, which is a review of all the activities and services of the business provider, as well as the types of customers or clients that these services are provided to, and cross-checking these with FSMA and the RAO to determine whether A, the business services fall within the scope of these regulations, and B, if there is a risk that the business could fall within the scope of the regulations. Our team is happy to assist with perimeter reviews, and we have completed this exercise for a number of clients. A common regulated activity that we often see is arranging deals and investments. A person is prohibited from carrying on the activity of arranging deals and investments in the UK unless they are an authorised or exempt person or an exclusion applies. This regulated activity is set out in Article 25 of the RAO and comprises of 2 limbs. So limb 1 includes making arrangements for another person to buy, sell, subscribe for, or underwrite a particular investment, which is either a security, such as shares and debentures, a relevant investment, such as options, a Lloyd's-related investment, or a structured deposit. The arrangement must be such that the arranger has the direct effect that their involvement in the chain of events leading to the transaction is of sufficient importance that without such involvement, the transaction would not take place. Limb 2 includes making arrangements with a view to a person who participates in the arrangements, buying, selling, subscribing for, or underwriting investments, which are either a security, such as shares and debentures, a relevant investment, such as options, a Lloyd's-related investment, or a structured deposit. The second limb is aimed at ongoing arrangements by a third party designed to facilitate others entering into transactions. Please. So where a relevant RAO exclusion applies, a person will not be carrying on a regulated activity, and the exclusions for arranging deals and investments are set out in Articles 26 to 36 of the RAO. Examples of some common exclusions which may apply include introducing, i.e. making arrangements under which individuals will be introduced to a third party is excluded, provided that the third party is authorised, exempt, or an exclusion applies to them. The introduction should also be made with a view to independent advice being provided or discretion being independently exercised in relation to investments generally or any class of investments. Arrangements made for or with a view to a transaction to be entered into by an individual with or through an authorised person will be excluded where certain criteria are met. Arrangements that do not or would not bring about the transaction to which the arrangements relate are excluded, and arrangements made for the purposes of or in connection with a person's main business of selling goods or supplying services is also excluded. So I'll now pass back over to Chris, who is going to discuss consumer credit.
Thank you very much, Kiera. That's great. Consumer credit. Very interesting topic, and we're seeing a lot of inquiries and a lot of transactions which revolve around this at the moment. It's a very complicated area, and the purpose of this short talk is simply to give an overview so that people can decide whether or not they feel that arrangements that they are thinking of entering into might actually fall within the regime. One thing to note first off is it applies to UK borrowers or UK-based contracts. So if you've got something which is sitting overseas, the UK regime won't bite. I'll say a little bit more about that in a moment. The regulations themselves are set out in the Consumer Credit Act 1974, the CCA. That had an old licensing regime which was replaced in 2014 by an authorization regime under Part 4A of FSMA. So the FCA became the relevant regulator for the purposes of consumer credit at that time. What actually constitutes a regulated consumer credit agreement and what is regulated credit is set out in Article 60 of the RAO. I think it's important before moving further forward to mention the by way of business test. So If the arrangements in and of themselves are not by way of business, then the regulation will not catch. I said I'd say a little bit more about the jurisdictional aspects. They're very, very complicated and at times a little counterintuitive. So if there is an overseas element to something you're considering doing, it is worth considering the jurisdictional aspects in detail with detailed advice, please. So what is credit? Credit is defined in Article 60L of the RAO, and it's got to be an agreement which provides credit, and credit is defined inclusively, and it includes a cash loan and any other form of financial accommodation. Pause there for a moment, because what does that mean? Financial accommodation has been considered in various case law, and it means that the debtor must have received some form of benefit to incur a debt that is due from the debtor on deferred payment terms. So that's credit. There are some things to unpack around it. It's got to be a contractual duty. If there's no contract, there's no legal obligation to pay anything in respect of the credit that's being granted, there's nothing to regulate. Payment has to be in money, and it must be deferred. And the case law states that it must be deferred for a significant time after the payment has been incurred. The idea here is to bar out short-term zero-cost credit, such as trade credit, from the regime. The legislation catches certain credit agreements, types of agreements, which are regulated. These can either be regulated credit agreements for the provision of actual credit, so actual money credit to someone, or regulated consumer hire agreements, where a person hires as consumer a particular thing and then makes regular deferred payments for the provision of the hire. A credit agreement is an agreement, so a binding agreement, between an individual or relevant recipient of credit. Who is a relevant recipient of credit? Well, it's a borrower or any other person which provides the borrower with credit of any amount. That is an individual, or it can be a partnership, provided that partnership does not consist solely of corporate bodies, or it can be an unincorporated body of persons, so an unincorporated association, a club, a buyer's club, provided that does not itself consist entirely of bodies corporate and is not itself a partnership. So that's a little bit convoluted, but the point is corporate traders and corporate debt is excluded. Otherwise, they'd have to regulate pretty much all of UK commerce. And what it's designed to do is protect the consumer. So individuals are the ones who are protected where they deal as consumer. The interesting point to note, of course, is that this can catch partnerships and in particular sole traders. It's also necessary to distinguish between an exempt agreement and an agreement with a limited exemption. An agreement with a limited exemption is an agreement which has certain aspects of it which are not regulated, but certain aspects which are. So it's very important to look at the actual nature of the agreements that are being entered into. What are you actually doing with the credit? And in some cases, even though overall you can avail yourselves of certain exemptions, you may fall within the regime in certain respects in other ways. That can affect the form of the contract that you enter into. And you may need certain specific clauses or specific ways of entering into the contract to actually make it work from a regulatory perspective. Why is that important? Why is it important? Well, it's important simply because of the consequences which Kiera outlined in her talk. And the consequences of getting it wrong, of course, are that you've committed a crime and the agreement itself is unenforceable without a court order. So if you're a lender, you can be in a real problem if you've not got it quite right. Some common exemptions which relate to agreements. So firstly, there are exemptions which relate to the nature of the agreement itself. Certain types of agreement fall outside of the need for regulation. These extend in particular to the purchase of land for non-residential purposes. That can be quite a useful exemption from time to time. There are certain other exemptions which relate to the nature of the lender. So credit unions, certain local authority bodies, certain quasi-government bodies are exempt. There are also very useful exemptions in commerce relating to the number of repayments to be made and potentially relating to the total charge to credit. These can be looked at particularly for smaller agreements or agreements which can be repaid with essentially zero administrative fees, zero cost to credit over a period of time. Finally, there are a bunch of exemptions which relate to the actual nature of the borrower themselves. These are very, very specific and very tricky. So again, this needs to be worked through in careful detail if you think you're falling into or close to any of these types of provisions. I'd like to pass over now to Olivia, who's going to talk a bit about something else that we see a lot of, which is bank of mum and dad lending.
Thanks very much, Chris. So as Chris mentions, I'll be talking through bank of mum and dad loans. This is a specific type of lending, which we often see. And I'll also be talking through the potential additional regulatory pitfalls that clients looking to make such loans could inadvertently fall into. The most common scenario which we come across when looking at bank of mum and dad loans is the scenario in which parents are looking to loan their children money in order to help them get onto the property ladder. However, we have also seen the situation in which friends have lent money to other friends under similar circumstances. However, it's the former scenario that we'll be looking at for the purposes of this webinar. In terms of the UK regulations which might apply in such cases, in addition to the consumer credit regime, which Chris has already discussed, and I don't propose to duplicate in this section, we'll also need to look at the FCA's mortgage regime. Kiera's already discussed the general prohibition set out in section 19 of FSMA, which prohibits persons from providing a regulated activity unless they are authorised or exempt. However, it's of course still irrelevant here. So when we're presented with this scenario, we need to look at whether mum and dad are providing a regulated activity, and if so, are they authorised or exempt? The most relevant possible regulated activity, which we'll look at here, is set out in Article 61, paragraph 1 of the RAO, which is FSMA's regulated activities order. And that sets out all of the regulated activities that fall within the remit of FSMA. And that provides that entering into a regulated mortgage contract is a specified kind of activity. Please. So in determining whether mum and dad are proposing to enter into a regulated mortgage contract, we'll need to look at are mum and dad providing credit to an individual or trustees? The likely answer to that will be yes. Does the contract require the obligation for the borrower to repay to be secured by a mortgage on land? Again, this is usually the case, and is at least 40% of the land used or intended to be used in connection with a dwelling? Most of the time, this definition is also met. So usually we can tick that they are going to fall within the remit of this regulated activity. The next thing that we'll need to look at is whether we are looking at an MCD regulated mortgage contract. And this is referring to the Mortgage Credit Directive, which was transposed into the UK on the 21st of March 2016. And what we need to determine and understand here is whether the loan is secured by either a mortgage or similar type of restriction related to residential property. Again, usually in these circumstances, the parents will be looking to secure their loan with a charge over the property. And is the purpose of the loan the charge to acquire or retain property rights in land or an existing or projected building. Something that's important to note is that the MTD does not apply to credit arrangements where the credit is granted free of interest and without any other charges, except to recover costs directly related to securing the credit. Since most parents are not often seeking to make a profit, it's not usually an issue. However, it's very much worth ruling out because we wouldn't want to fall in breach of any of the regulations. So looking back at the requirements under the prohibition, we're likely to understand at this point that the parents are most likely to have fallen within the scope of Article 61, paragraph 1. It's unlikely that they will be authorised, and so we'll need to look at whether any of the exemptions set out in Article 61A paragraph 1 or 61A paragraph 2 of the RAO apply. So these would include regulated home purchase plans, limited payment second charge bridging loans, second charge business loans, investment property loans, exempt consumer buy-to-let mortgage contracts, exempt equitable mortgage bridging loans, and exempt housing authority loans. In the context of what we usually see, these exemptions aren't often met. However, what's also important to check is whether the arrangement falls within the scope of the Section 22 FSMA business test, i.e., is the loan being made in the course of business. And what we'll usually look at to determine whether this threshold is met is there a degree of continuity, i.e., do mum and dad offer similar loans in the course of business usually? Is there a commercial element to the loan? So are mum and dad hoping to make some money off of it? What's the scale of the activity? Is this a one-off or is it more frequent that they make these types of loans? What's the nature of the relevant activity? So is it purely to assist their child with getting on the property ladder, or is there more to it? What's the proportion of this activity compared to the other unregulated activities carried on? It might seem obvious in the context of looking at this. However, I should flag that we ought not to be flippant regarding any of these, and it's always worthwhile documenting the reason why this exemption applies and giving evidence to back this up to avoid the risk of us falling foul of the regulations. So if we do then decide to move forward with implementing a proposed Bank of Mum and Dad loan, there's a number of other factors which it's worthwhile checking. So you will need to carry out due diligence, so the normal due diligence that you would carry out in purchasing any residential property, so checking whether there are any overriding interests registered at the land registry, what's the valuation, are there any environmental issues. You also may want to be registering a charge, in which case registering the mortgage at the land registry will be required, as well as at Companies House, together with drafting the loan agreement or the facility agreement itself. We work very closely with our residential property team on these projects, so we'd be able to assist with all aspects of these matters if required, right through from the regulatory review to the corporate and residential property implementation. I'll be passing you over to Luke now to run through payment services.
Great. Thank you, Olivia. Yes, so my name's Luke Wilkins, and I'm an associate in the corporate team here at Myerson. And today I'll be discussing the regulatory landscape around payment services in the UK. That's going to include a brief overview of the scope of the rules, the key legal requirements for compliance, and the forward-looking trajectory based on recently published guidance. So first of all, let's just look at the regulatory landscape, and I will caveat this to begin with, just to say that this is the current regulatory landscape, and as we will see a bit later on, there are proposals to change this framework quite substantially in the near future. As I say, currently there are three main bodies which between them deal with regulation in payment services, and they are, as set out on the slide, the FCA, the Payment Services Regulator, and HM Treasury. In terms of each of their roles, the FCA are the key regulator here, so they oversee authorization, supervision, and enforcement of the payment services regulations. The Payment Service Regulator, known as the PSR, they oversee competition and innovation in payment services. And finally, HM Treasury, they play a role in setting the overall policy framework. In terms of the regulations themselves and their scope, it's important, firstly, just to note that payment services regulations do apply to any firm providing payment as a service as a regular business activity in the UK. And examples of this will include things like money remittance, so credit and debit transfers, payment initiation via apps, account information services, etc. So the scope of these regulations, due to being quite broad, will catch a range of different types of institution, and that will be things like anything from a bank to fintech firms, e-money institutions, or other types of payment institutions operating in this area. Now, whilst there are certain exemptions to these regulations, such as store cards or low-value transactions, it is really important to take advice when determining whether or not your firm is conducting an activity within the scope of these regulations. And that's because failing to do so and failing to get it right does carry a risk of potential criminal liability. And that leads us on to the regulatory requirements. So what's actually required if you are caught by these regulations? First of all, the compliance under the payment services regulations are a combination of prudential and conduct obligations. First of which that I'd like to discuss is authorization. So firms that operate in payment services who are not seeking to rely on one of the exemptions must obtain authorization. And in order to achieve authorization, this is a process which, again, Myerson have helped a number of clients on, and it's something that we can absolutely help you with if it's something you're considering. One of the main things that you need to think about when seeking authorization is being able to demonstrate sound governance and risk management. There is also a regime in which smaller payment services providers can register with the FCA for a light touch style authorization, whereas if you're operating a larger payment services provider, full authorization must be sought. The second limb that I'd like to discuss is safeguarding of customer funds. Now, this is seen as an absolute of paramount importance. If operating a non-bank payment services provider, there is an obligation to ring-fence balances in segregated accounts, and the reason for this is to protect against insolvency scenarios. Thirdly, the conduct rules. So the conduct rules really demand transparency. One of the things I'd like to touch on when talking about transparency is pre-contract disclosure on fees. You may be aware of the recent case law decision regarding the disclosure of commissions. And it was in this case that the Supreme Court considered the role of car dealers, and it confirmed that car dealers do not owe any fiduciary duties to consumers in standard motor finance arrangements. However, the really interesting part of this judgment was the discussion around the unfair relationship that can exist between a car dealer and an end consumer, where the car dealer has some discretion to set an interest rate which is within a pre-approved lender range. And the discussions that took place in that case strongly suggest that discretionary commission arrangements, especially where there's poor disclosure of those arrangements to the consumer, are likely to be deemed as unfair, and they are open to some scrutiny. So that's something to be aware of. We have published a blog which discusses this recent decision in some more detail, so please do visit our website if you'd like to read up on that a bit more. And finally, it's worth noting, in terms of customer authentication, this is mandatory for online, save for some low-risk scenarios. Finally, I'd just like to take a moment to consider the forward-looking approach of the UK government. And one of the recently published articles setting out the nation's payments vision. This was published by HM Treasury in late 2024, and it sets out a path focusing on 3 key aims. The first of all, it's a focus on innovation in open banking and real-time payments. This includes quite an interesting idea around exploring the use of a retail central bank digital currency or a digital pound. It also focuses on competition. So this is the idea of increasing choice for consumers by encouraging competition in the marketplace. And as part of that, there is a real desire to reduce the regulatory burdens on payment services providers. And one of the examples of this is the proposed reform of the governance of Pay.uk. I think it's important to acknowledge that there is a balance to be had here between regulations being put in place to protect consumers, but also having in place proportionate regulation for smaller and more innovative firms. And finally, security. The key message here being that the top priority is fraud prevention. There are a couple of other recently published papers that I think are worth touching on here. So the first of which, regarding safeguarding, is the FCA's policy statement, which they released in August this year. The FCA have stated that they are strengthening the safeguarding regime, and that is being put in place in order to address perceived weaknesses in firms' current safeguarding practices. And the aim of this will be to better protect customers of payments and e-money firms that fail. There is a new set of rules coming into place on the 7th of May 2026, known as the interim rules or the supplementary regime, and no doubt there'll be more information made available about that in the near future. And then the final thing that I wanted to talk about was the September 2025 consultation on a streamlined approach to payment systems regulations. Now, this consultation sets out a vision for a more streamlined approach to regulating payment services. There are a few ways in which it's looking to do that. I think probably the first one and the most extreme is the proposed abolition of the PSR. The idea being that the FCA will absorb those functions. And the idea here is that this will support growth. It will ensure that regulation can be targeted and proportionate. It will ensure that regulations are transparent and predictable, and ensure that regulations are able to adapt and keep pace with innovation. In the consultation paper, it sets out the fact that the FCA is well placed to inherit the PSR's responsibility for regulation of the UK payment systems, and that's because the FCA clearly have a wealth of experience in regulating financial services, and it already regulates many payment services firms. One of the things that's important to note about this proposed new system is that it will not result in new categories of persons being brought into the scope of the payment services regulations. There will also not be any new regulated activity which is created in connection with payment systems regulations, and no new categories of persons requiring permissions under FSMA. The intention is that the FCA will have the powers for when it acts in relation to payment services, which are broadly equivalent to the existing PSR's powers. We'll see how those proposals start to take shape in the coming months. And that concludes my overview on payment services, and I'll now hand back over to Chris, and he's going to talk a little bit more about financial promotions. Thank you.
Thanks, Luke. That's great. So we've seen that FSMA catches regulated activities, but it also catches marketing, specifically the marketing of investments or investment opportunities. This bit is the marketing bit. Section 21 of FSMA says that a person must not, in the course of business, communicate an invitation or inducement to engage in an investment activity or a claims management activity unless they are authorised or the content of the communication is approved by an authorised person or it is exempt. So what does this really mean, and how do we decide whether or not what we're doing is a financial promotion? There is some useful guidance in the Perimeter Guidance Manual, PERG-8 specifically, which is a good source of reference if you think that the communication you're putting out in the course of business might actually relate to a specified investment. First thing you've got to look at really is whether a communication is in fact being made, or are you causing it to be made, and then whether or not that communication is an inducement or invitation to engage in an investment activity. And this means that it has to be a significant step in the chain. It has to be a vital link, essentially, in the chain that persuades or causes a relevant individual or entity to enter into an investment agreement. That can throw up some very interesting issues, in fact. It's worth also mentioning the jurisdictional effect. If you're doing something which sits outside the UK regulator essentially doesn't take a view on it. It may well be that the jurisdiction that you're operating in does have regulation which will apply. Finally, we can look at exemption of communications, although those are fairly limited. However, there are some specific exemptions which are of great use in common practice within business. So looking at some common exemptions. Firstly, generic promotions. Simply saying that a particular form of investment, or even a particular investment in and of itself, without going further and offering some sort of invitation or inducement to actually enter into it, is likely to be a generic promotion. Generic promotions can be exempt. There are other sets of exemptions which relate to the type of individual or entity in question and to whom the communication is made. These, or the typical ones that are often relied upon, revolve around communications made to investment professionals or targeted solely at sophisticated investors or high net worth investors and high net worth trusts and companies. There are also specific exemptions which can often be useful for business angels and business angels networks, and in the context of takeovers and mergers and acquisitions activities. However, be warned, these exemptions have some specific rules relating to them, and in many cases specific risk warnings which need to be made apparent before the relevant communication is made or given. So one has to be very careful to make sure, even though you may think, oh, that person I'm dealing with is high net worth, there is a process that has to be followed in order for the exemption to apply. We can help, of course, with all of that, and that can be very relevant for small private companies seeking to raise money, which we often see in terms of how they go round and market that opportunity to people. I hope that talk has been helpful, and clearly if you do have any questions, it would be great to take them. As you can see from this slide, we've got our website address and our email for general inquiries, and our personal email addresses were on the second or third slide in the slide deck. So please feel free to reach out if you have any questions, concerns, or anything you wish to talk to us about. Thank you very much for your time, and thank you for watching and listening.